All right, back on the record in the Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Cochran, Mr. Thompson, Mr. Scheck, people represented by Mr. Kelberg, Ms. Clarke, Mr. Clarke, Mr. Harmon. Jury is not present. Counsel, anything we need to take up before we invite the jurors to rejoin us to conclude the cross-examination of Dr. Gerdes?
Your Honor,
Mr. Kelberg, good morning.
good morning, Your Honor. From my attire, you may expect that I was not anticipating a visit to your courtroom this morning, and that was the case, except that I was informed by way of a communication between Mr. Yokelson of our office and Mr. Douglas of the defense late Friday afternoon that in the most recent witness list for this week, the defense has named Drs. Baden and Wolf as, I think, witnesses or prospective witnesses 4 and 5. I had asked Mr. Yokelson on Friday, August 4th, to make a formal request to Mr. Shapiro for any report from either of these doctors. We have never received a report from either one of them. And this morning I spoke to Mr. Cochran, who indicated that there may not be a report. I pointed out that when Dr. Baden twice has been retained by our office, he has always submitted a report. But setting that aside, I learned to try cases when this court, I believe, learned to try cases before reciprocal discovery, and so trial by ambush is not an unusual procedure by which one learns to do cross-examination. But if this is to be a search for the truth, and if there is to be the impact of the reciprocal discovery provision of the California Constitution, I think it's incumbent that both sides share their materials. In this regard, if there's not going to be a report, if they've made a tactical decision not to have a report prepared, that'll be the subject of cross-exam, but I'd like to see every note that these people have. I think it's important to remember we know Dr. Baden has been involved with the defense since at least June 17th, because we have the picture of Dr. Baden with Dr. Huizinga examining Mr. Simpson's hand, as I recall, one of the exhibits that's been marked. And so I would like whatever they have, because I have no idea what they're going to testify to. I had a brief conversation with Mr. Shapiro about 2 weeks ago where he indicated that if one or both Drs. Baden or Wolf were called, that it might be on a limited basis and he would have a report. Apparently that may be changing. Again, I'll cross-examine these people if I don't get a note and I don't get a report, but I don't think that the people's will for reciprocal discovery is advanced if in fact I do not stand here and make a request through the court to get what is in fact our entitlement under that California constitutional provision.
All right, thank you, Mr. Kelberg. Mr. Cochran. Good morning.
Your Honor, in this matter, we are very, very aware of our responsibilities under reciprocal discovery. I think you, I, and Mr. Kelberg all learned how to try cases under the old system, and we've adjusted to the new system, obviously. That's part of being a lawyer, I suppose, and being fairly intelligent is the ability to adapt. The problem is Mr. Shapiro is not here and may not be here today. He'll be handling any witnesses that we call from a forensic pathology standpoint. And he's mindful of his obligations. It's an interesting argument. I just like to point this out, Your Honor. If witnesses don't normally write reports, we don't have to ask them to do a report. In this case, several times we said, write a report so we won't have any problem. Then we still get whipsawed. I mean, you can't win. And people should understand that. You can't win. If we ask to get a report, or they don't normally even write a report, then the prosecution says, well, gee, that report came late, and we want to delay. So, you cannot win. Let's just make that clear. And the search for truth works both sides. It's in North Carolina, it's everywhere, and we want to search for truth also. But let me just say this. If there are notes, he's entitled to notes. I can tell you they don't normally write reports, but if Mr. Shapiro makes the decision, as we've done with the other witnesses, say, write a report so we don't have any problems with these people, then we'll do that too. But I can't say he's not here yet.
Right.
But we will do.
We'll wait for Mr. Shapiro to write.
Yeah, and Judge, if he doesn't come, he may be working with him. I will speak with him and get word and report it back. And Mr. Kelberg, we can let him know at his office.
And Your Honor, Mr. Cochran was kind enough to identify the last name on this witness list, who none of us was familiar with, J. Uko, U-K-O. And apparently this is Dr. Uko, a pathologist from Buffalo. My request goes to Dr. Uko as well as Drs. Baden and Wolf. And I have nothing to say about North Carolina. I'm not trying to make a pitch for anything other than the limited responsibilities I face at the end of this week.
Well then, Mr. Kelberg, why don't you see if you can't contact Mr. Shapiro.
Or I'll do it for him, Your
All
Honor.
right.
Thank you.
And
Okay.
I'll give Mr. Cochran my office.
All right. Thank you, counsel. All right, Mr. Clarke, we ready to proceed?
Actually, two items, if I might bring them to the court's attention. The first relates to the grant proposal, and it's my intention the court may recall that that proposal was faxed to this courtroom. Having reviewed that material, there are two areas of inquiry that I wish to make, but not as to the specifics of the technology contained in it. I wanted to bring that to the court's attention before I launched into that.
Perhaps he could, Mr. Clarke, at sidebar or in a sealed record can indicate what that is so that I can just...
What's the nature of your inquiry, Mr. Clarke?
Approaches in the laboratory of the witness. I can be more specific, but I'd like to do it outside the presence of the witness.
I'm just
All right.
have those proprietary...
Dr. Gerdes, why don't you wait outside, please?
Your Honor, could we approach on this because I just have that proprietary...
Mr. Clarke
concern.
indicates it has nothing to do with the particular topic, just the technique involved.
Correct. The two areas of inquiry that I wish to make is there is reference in the proposal and a description of this witness's laboratory as being a laboratory that uses primarily, quote, home-brewed, unquote, methods, as opposed to kits. And I think that's an area that's significant in the context of this witness's prior testimony. So that's a fairly brief and narrow area. Actually, it's probably a couple of questions. The second area relates to a further description of the laboratory as a progressive reference laboratory that rapidly seeks to implement new DNA technologies. And I think that obviously is relevant to this inquiry as well. So my intent is not to get into the specifics of the proposed technique whatsoever.
All right, thank you for the warning.
The second relates to discovery. And in the same vein as Mr. Kelberg, I'd like to give the court a very brief history of what's occurred since last Monday. Either Tuesday or Wednesday of last week, I was provided by Mr. Scheck 6 pages of Dr. Gerdes' notes. At the noon recess on Friday, the court may recall Dr. Gerdes referred in his testimony to further notes that he had in his possession. And at that time, per Mr. Scheck, those further notes were, quote, provided long ago to the people in discovery. Mr. Blazier indicated at that time that that was not the case and that in fact they were not provided to the people because they were never asked for. Now I think that's an important comment, particularly in light of Mr. Cochran's comments just a few moments ago, that the people are entitled to notes. And so here's a situation in which there were clearly notes that existed. Dr. Gerdes had them in his notebook. The defense was apparently aware of them, and yet we were denied discovery of them until Friday at noon of last week. Now, copies were made of those notes. They contain some important information that I will further address the witness about. We're not seeking a remedy as to this witness at this point, but I think it's important that that event be known, particularly in light of what Mr. Kelberg just stated, and also in light of what will be the approaching witnesses, at least by the information that we received last Friday as to the next DNA witnesses. It's my request that with respect to those DNA witnesses, and there are at this point 3, apparently to follow Dr. Gerdes, that Mr. Harmon would ask a brief moment to address the court about obtaining discovery of those materials immediately, if that's acceptable to the court.
No, I think you just made the request on his behalf. I don't think you need to add anything more to that other than to name the individuals.
Well, at this point, I think I would like to add that we have been notified that those individuals are Dr. Speed, Dr. Mullis, and Dr. Shields, and at least in terms of any witnesses, particularly those who may involve statistics, that frankly it's a bit inconceivable that there aren't notes about calculations of population frequency data related to this case, and yet at this point we've received 0.
Just the first matter is that I'm glad Mr. Clarke raised this issue. Mr. Blazier and Mr. Douglas, as the court recalls, were handling the discovery and showed the court various notes and had made a legal determination, since they're the California lawyers, under the Hines case as to which notes were turned over or not. And the 2 sets of notes that we're talking about is that Dr. Gerdes made some handwritten notations when he did his lab tour, and pictures were taken when all the LAPD people were there and they took the same pictures and they were there on the same tour. I had mistakenly believed that those notes had been turned over. That was just a mistake, and they were given to them at that time. I was informed by Mr. Blazier that those were in the category of notes that are turned over when the witness testified. They're not, they were not notations of any reports or calculations or examinations that he had done. I had made sure that the charts, the contamination analysis, the unexpected allele analysis has been turned over months ago, along with Dr. Gerdes' report. The other notes that Mr. Clarke is referring to are handwritten notes that Dr. Gerdes made that are really inventories of what is contained in the raw material. In other words, he has a series of notebooks here that contain some but not all of the data, and on the cover page of each section, he has notations about what is, it's like a table of contents as to what's in the other materials. And I would just note in passing that at various times when I approached the witness stand when Gary Sims was testifying, I know it was true of Renee Montgomery and Mr. Yamuchi, other witnesses, they had similar kinds of table of contents notes in terms of the materials and other notations to themselves that I suppose I now understand under the rules I could have asked for at that time, but I saw what they were. So those are the nature of those notes, and I just want to make that clear because I don't want to get into any trouble on discovery obligations. I'm relying on the California lawyers here who have been to the court and have gone through these materials.
Well, at this point, since Mr. Clarke is not asking for any particular sanction, let's not waste a lot of time.
I just wanted to make clear to you exactly what the nature of this was so that
Now, having said that, what about the next three?
well, Mr. Neufeld will address Dr. Speed, who he's going to put on, as far as and he's actually putting on the other two witnesses. And at this time, we have nothing that, no reports and no notes in the nature of anything that we think we have to disclose at this time.
Right, even in the nature of statistical calculations?
No,
or
there's no, I can, unless they're doing something now, there's nothing in the nature of statistical calculations that Dr. Speed is doing. I feel quite certain of that. But again, that's, Mr. Neufeld would know better than I, but I feel fairly certain of that.
All right. Deputy McNair, let's have the jurors, please.
Before he asks any questions about the term home brewed, that we can find it in the report, he doesn't know the page. Let the record reflect that we've been rejoined by all the members of our jury panel. Good morning, ladies and gentlemen. Dr. Gerdes, would you resume the witness stand, please? All right, the record should reflect that Dr. John Gerdes is on the witness stand undergoing cross-examination by Mr. Clarke. Good morning again, Doctor.
Good morning.
Doctor, you are reminded, sir, you are still under oath, and Mr. Clarke, you may conclude your cross-examination.
Thank you, Your Honor. Morning, ladies and gentlemen. Morning, Dr. Gerdes.
Good morning.
Dr. Gerdes, you recall testifying last week that at the LAPD laboratory where DNA extraction is done, that the laboratory does not use a laminar flow hood.
Yes, that's correct.
Now, you visited the laboratory, is that correct, in December of '94?
Yes.
And you took a tour of the lab, is that a fair description?
Yes.
And that tour included the DNA laboratory, correct?
Yes.
All right, Your Honor, with the court's permission, I'd like to display to the witness Exhibit 1301, which is a photograph of the laboratory. Dr. Gerdes, can you see that from that angle?
Yes.
And in particular, with respect to this photograph, does this photo show the hood that you described during your testimony in the DNA lab at the LAPD?
It does.
Now, as far as your tour of the laboratory back in December, did you take notes during that tour?
Yes.
And in fact, did you create rough, let's say, diagrams of various locations at the DNA laboratory at the Los Angeles Police Department?
Yes.
Your diagrams included the area where DNA is extracted, is that right?
Yes.
As well as where the hood is located?
I believe so, yes.
In terms of your keeping those notes, did you attempt to be as accurate as possible, setting aside exact scale?
Yeah, there was no scale, and it was just to give me a rough idea so that I could go back to those and recall what I've seen.
Now, did you have occasion to provide to the people last Friday notes that you took, including a diagram or diagrams of this particular tour?
Yes.
All right, Your Honor, I'd ask to have marked as people's next in order a single page, which I'm showing to counsel.
569.
May I approach the witness, Your Honor?
You may.
Dr. Gerdes, showing you People's Exhibit 569. Does that appear to be a Xerox copy of one of your notes?
Yes.
And is that in fact the note that contains a rough sketch or rough diagram of the extraction area at the Los Angeles Police Department?
Yes. These notes were taken on 12/19, the first visit.
December 1994?
Correct.
Your Honor, may I display a portion of this note also?
You may.
Now, I don't know, Dr. Gerdes, can you see the screen from there?
Yes, I can.
Does this appear to be the lower portion of that single page of notes, People's Exhibit 569?
Yes.
And is this your rough sketch or rough diagram of the DNA extraction area at the LAPD?
Yes.
Now, there appears to be a fairly long rectangle, comparatively speaking, in the middle of the diagram, which is, I'm not sure I can really read it, but it looks like it has two words. Is that right?
Yes, it says sorting
And
bench, I believe is what it says.
just
right
to
there.
the left of where the arrow is located?
Yes.
All right, and then off to the left of that long rectangle, towards the top, there appears to be a square with the term hood written inside.
Yes.
Now, off to the left of that, what are the other two words that precede the word hood?
It says lam flow.
Meaning what?
Well, at that time, I hadn't really noticed that this wasn't a laminar flow hood. I put down laminar flow, and I didn't really realize until the second visit that this was not a laminar flow hood.
So upon your initial visit to the Los Angeles Police Department, you recorded in your notes laminar flow hood to describe that particular hood.
Yes. That's incorrect.
All right. Was that a mistake?
It was something that I checked later on and found to be a mistake, yes.
Now, Dr. Gerdes, you testified last week that in your opinion, DQ alpha PCR typing is not ready for forensic testing, correct?
In my opinion, yes.
And that continues to be your opinion today, correct?
Until adequate controls are incorporated to control the contamination problem, that continues to be my opinion.
And it's your opinion that it should not be used for either including potential donors of DNA or excluding them? Oh.
Yes.
Are you familiar with a method of typing what's called mitochondrial DNA?
Yes.
Does that use PCR also?
It does, to produce a product that's then sequenced.
Okay, and without getting into great detail, does that method involve, after amplifying a sample, basically looking at the pieces of DNA information, these letters, A's, T's, G's, and C's, one by one?
Yes.
Is that a method that is in place in forensic laboratories around the world?
Not on a routine basis.
In your opinion, is it ready for use in forensics?
No.
You referred last week to a number of scientific publications discussing DQ alpha as, and I think you used the term demonstration papers.
In my opinion, that's what they are, yes.
Now, you have testified for approximately the last 5 years that PCR DQ alpha typing should not be used in forensics, correct?
I've been very consistent in expressing my opinions about contamination and my concerns, yes.
And that's been for about 5 years?
Yes.
And you've actually come to courtrooms like this and testified the same way as far as that particular opinion for the last 5 years?
That's true.
As far as your own laboratory, is it correct that most of the methods that you use in your lab in Denver are methods that don't involve the use of kits?
No, that's not true.
Are most of the tests that you use tests that do involve the use of kits?
Yes.
You mentioned chlamydia. That's one of the tests for a sexually transmitted disease that you use a kit that's actually manufactured by Roche, correct?
That's correct.
What are the other tests that you use a kit in?
Oh, well, there's the vast majority of the testing our laboratory does. Testing for antibodies for HIV, HTLV, I can go on and on. It's probably a page-long list of things, most of which we do use FDA-approved kits.
Are any of these kits manufactured, well, let me rephrase that. Were any of these kits developed in your own laboratory?
No.
Is it then your testimony that most of your methods, well, let me strike that. Rephrase that if I may, Your Honor. As far as a grant proposal that you described during your direct examination, do you recall that testimony?
Yes.
This related to a grant that you have fairly recently received, is that
Yes.
right? That related to a particular technique developed in your laboratory, is that right?
It hasn't been developed yet. That's what the grant is for, is we're proposing to develop that technology.
So the grant is basically your laboratory receiving money to develop a particular technique.
Yes.
As far as that grant, does this process involve your laboratory submitting a proposal to a government agency?
Yes.
And then and the government agency then uses that proposal to decide whether or not to grant your laboratory money to look at this proposed technique.
That's correct.
As part of that proposal, are you required to describe a number of different things in this application for money,
Of course.
including the technique that you wish to try to devise,
That's true.
as well as information about the laboratory,
Yes.
as well as information about the individuals who would be involved in developing this technique?
That's true.
Gerdes, in this particular grant proposal, are you familiar with it?
Of course,
And you've read the entire document?
I wrote it.
You wrote the entire document, all right. Isn't it true that in that document, you state in reference to your laboratory, most of our testing could be described as home brewed as opposed to commercial kits?
Ask that the witness be shown the entire paragraph.
Show him what page it is of the,
Dr. Gerdes, if I can refer you to what appears to be page 31 of the proposal.
What part of this page are you at? Oh, here I see it. Okay.
That statement that I just read, was that a statement that you wrote in that proposal?
Yes, it refers to the fact that in our laboratory, we do go through some research and development, and then it's progressed on to testing this routine, and it has to do with our research and development department. It has nothing to do with the testing menu that we offer at the present time, which is what you asked me initially.
Well, is it then correct that most of the testing methods in your laboratory are, quote, home brewed?
Well, most of the newer methods, this is talking about the next generation, if you will, from our laboratory. Most of what we do at the present time are kits that are FDA approved. What we hope to do is to move into the field of development of new diagnostic technologies, and we have been involved in that process since I've been hired. That's one of my jobs. But we are not yet using those types of tests for routine testing.
What does home brewed mean?
It simply means that you're developing the test yourself as opposed to buying a kit.
You've described the chlamydia test kit as FDA approved, correct?
Correct.
What are the other testing kits in casework that are FDA approved in your lab?
For DNA, or?
Yes.
That would be the only one for DNA. All of the kits that we use, other than that particular kit, involve serological methods.
Which don't involve testing DNA.
Correct.
Could I have just a moment again, Your Honor? Now, as far as degraded samples, Dr. Gerdes, and we spoke about that last week, your concern about the reliability of results obtained using PCR-based testing in forensics is based really on the nature of the specimen. In other words, the fact that it's a blood stain that may have been on a sidewalk as opposed to blood removed from a patient in a hospital, right? Is that correct?
That's one of the aspects, yes.
Now, as far as this use of DQ-alpha testing, are you familiar with its use on cases in which defendants have been, for instance, in prison for a number of years?
Yes.
And in fact, DQ-alpha testing has been used to determine years later that a person may have been innocent of a crime. Is that correct?
It's been done for that, yes.
And in fact, inmates have been released from prison as a result of as a result of typing results obtained by using this PCR DQ-alpha method.
That's true.
Those cases may involve cases that occurred years earlier. Is that correct?
That's true.
Your concerns about degraded samples would apply equally to those cases as well. Isn't that true? Where the samples may be years old.
Yes.
Is it your view that under those circumstances that inmates should not be released from prison as a result of DQ-alpha typing conducted what may be years later?
I think you have to take every case by case in terms of how much weight to put on that or whatever, but my position has always been consistent that until you have more adequate controls, and in specific in those kinds of samples where they're old, degraded, and in small quantities, this technology has a tremendous risk of error.
As far as the samples that were not amplified and typed at the Los Angeles Police Department, and I asked you a number of questions about that last week, correct?
Excuse me, go ahead.
Sure. As far as the samples that were not amplified and typed, in other words, they weren't subjected to this PCR process and typed at the LAPD, do you recall that?
Yes.
Isn't it true that independent laboratories who reach the same results adds confidence to the results themselves? In other words, the layer or level of confidence that an analyst can have in the accuracy of those results.
It will give you confidence from that step on, but what happens in the previous steps can't be cross-checked.
Isn't it correct, Dr. Gerdes, that if you work in two separate labs and try and come up independently with the same result, then that's always going to be a confirmation of the test and give you more reliability?
Only if both labs handled totally those specimens independently. That means they're collected and sent, as we described earlier in the clinical situation, to both labs and are never exposed one lab to the other.
Haven't you previously testified to what I just stated, Dr. Gerdes?
I may have, but that was prior to more recent cases where it's become more and more obvious that there are problems early on.
Strike non-responsive, Your Honor.
Sustained. The last part of the answer is stricken and jury is to disregard.
Dr. Gerdes, haven't you testified previously to what I just read to you?
Yes.
Samples 48, 50, and 52, the bloodstains at Bundy, were swatches sent to different laboratories, correct?
Correct.
As far as Cellmark is concerned, and I'd like to shift your attention to known samples, or if we use the term reference samples, can that indicate, as far as these questions, we're talking about known samples from the people who may be involved in a case, all right?
Correct.
Referring in this case to Mr. Simpson,
Yes.
as well as Nicole Brown and Ronald Goldman.
Yes.
Isn't it correct that when Cellmark conducted its testing on the known samples, they were done blindly?
They were coded, yes.
And by coded, what do you mean?
They were given a code number when they arrived at the laboratory, and then the technician would type it from there.
Well, in addition...
So blinded, if you want to call it that, yes.
In addition to having a code number, isn't it correct that the actual known reference samples weren't labeled for Cellmark's purposes as to who of the three people they came from?
As they received them?
Yes.
I don't recall if that's the case. I know they were labeled with a code name, but I'm not sure if they had also the information as to who they were from. I'd have to double check.
All right. Do you have information at your hand that would be able, would help you answer that question?
Perhaps I do. That appears to be correct. They were labeled with a code name, and it doesn't have who it is next to it.
So Cellmark was in fact given these known samples, and they were coded C1, C2, and C3, weren't they?
That's correct.
And they were not given information about which sample was Mr. Simpson's,
That's correct.
which sample was Mr. Goldman's,
Correct.
and what sample was Nicole Brown's.
Correct.
In your opinion, is that an important step?
I think that's the way to do it, yes.
Isn't it also correct that as far as the DQ alpha types that the Department of Justice typed, that those reference samples were done after most of the evidence was typed?
I believe that's true.
And in fact, isn't it true that the known samples were not typed until after there were PCR results on several of the Bundy blood drops at the Department of Justice?
I don't recall if that's specifically the case, but that's possible.
after several of the stains from the Bronco were tested by the Department of Justice?
That's possible.
Well, isn't it true?
I don't recall that. I can look it up if you'd like and try and look that up.
Is that something you think you can find in your notes?
I think I can.
All right.
Just curious.
That appears to be the case, yes.
Those reference samples were typed after, for instance, one of the blood trail at Rockingham was typed, one of those drops
That's correct.
also,
That's correct.
as well as most of the samples on the glove,
Yes,
as well as most of the samples on the socks as well.
at DOJ, yes.
In your view, is that also an important step to take, to type those reference samples after evidence is typed?
I think that was appropriate.
Now, I'd like to return, if I could, Dr. Gerdes, to the fact that in your laboratory, you develop methods for use in DNA typing in your lab, correct?
Correct.
Part of your function at the laboratory, and I believe you said you're director of the research and development arm of the lab,
That's one of the titles I have, yes.
and in that role, as far as the research and development role of the laboratory, you try to develop methods that other laboratories can use, correct?
Yes,
And in fact, your proposal for a grant is one such proposal, to develop a specific technique to type DNA that other laboratories can use.
hopefully, yes.
You want to make sure that your techniques operate properly before they're used, for instance, in clinical casework.
Of course,
That's absolutely essential, isn't it?
of course.
You also want to be able to market or sell these methods as quickly as possible. Isn't that correct?
Yes,
Is your laboratory committed to rapidly implementing DNA technology to diagnostic testing?
yes,
And in fact, you want to get these new techniques out there and marketed as soon as possible, correct?
we have a projection as to how long this will take. The technology we're describing is so new, it's going to take 3 to 5 years before we even confirm the technology itself. So we're really not talking about marketing for that many years.
Well, Dr. Gerdes, isn't it true that your laboratory is committed to getting these newly developed techniques into the clinical laboratory as quickly as possible?
We would like that, yes.
And in fact, that's what you told the United States government as far as your grant proposal, didn't you?
Yes.
As far as, and we've talked about PCR as one technique, there's also the technique of RFLP that you discussed in your direct examination, correct?
Yes.
Can we call those different methods or methodologies? What word would you feel comfortable with to describe that they're two different techniques?
Different methods is fine.
Isn't it correct that a consistency in result, that is, that a result is giving the same answer from both PCR testing as well as RFLP testing on the same sample, is one measure of the accuracy of the PCR technique?
It does tell you some information. The RFLP is a more discriminating test, so you would expect that there would be a number of occasions where the PCR would include someone and RFLP would exclude them.
Okay. And that's certainly one characteristic of RFLP typing, that it's more powerful in telling people apart, correct?
Correct.
If you saw PCR results that, for instance, exclude someone, and from the same sample an RFLP result included the person, that would give you great pause for concern about PCR typing, wouldn't it?
Not necessarily. Depends on how many probes, and in any genetic analysis you look at multiple markers, and once you find an exclusion, if it's confirmed especially, then you have to believe that.
Well, let's make it more specific. Let's say that on a particular sample you saw a 5-probe RFLP match. That would be powerful evidence of who that sample came from, wouldn't it?
It would.
If you saw a PCR result on the same sample that revealed results that excluded that person, wouldn't that give you concern about the PCR result?
In a forensic setting, yes.
So therefore, if there is consistency between the RFLP results and PCR results, doesn't that give you greater confidence in the PCR results?
It can.
Well, haven't you testified previously, Dr. Gerdes, that you have no problem with the RFLP technology?
I have.
And you've testified in this case that you have no problem with several of the RFLP matches in this case. Isn't that right?
That's right.
Isn't it in fact the case that if there's an RFLP match on a sample, in your opinion, that validates the PCR result on that sample?
It can.
Haven't you previously testified that it does?
I probably have in the past, yes.
Isn't it true that if there's an RFLP match on the same sample that a PCR result is obtained, that RFLP match confirms the PCR result on that sample?
Of course, you have to look at the samples. Even in RFLP, there are going to be circumstances where those kinds of results need to be looked at with suspicion in terms of whether it's a mixed sample and the same sorts of issues that we discussed earlier in general in terms of DNA technology and forensics. So you can't make a broad, blanket, general statement like that. You need to look at the circumstances for each item, even in an RFLP test.
Dr. Gerdes, haven't you previously testified that if you get a PCR result on a sample and you already have an RFLP result on that sample, that RFLP result confirms the PCR result?
Assuming there are no difficulties or suspicions about the nature of the sample or mixtures or other complications like that.
Isn't it true, doctor, that if you cross-check the PCR results and RFLP results on enough samples in a given case, that is a significant method of validation?
I wouldn't call it validation.
Haven't you used those exact words, Dr. Gerdes?
I believe maybe 3 years ago I might have.
And in fact, those words that you used were just as I stated to you, were they not? That if you cross-check the PCR results and RFLP results in a given case on enough samples, that is in fact a significant method of validating the accuracy of the PCR results.
I probably said that, but you have to look at the context around then. I'm sure I also said that you have to look at the sample and the things that I've talked about here.
When you said it, did you mean it?
Yes.
I have a moment, Your Honor. Didn't you in fact testify to what I just read to you only less than 1 year ago?
I don't remember how long ago it was.
Should have an opportunity to see what he's referring to. I thought those were the rules.
We'll at this point, but if you're going to confront him with the specifics, we need to see it.
I understand. Do you recall testifying in a case involving a defendant named McIntosh in the state of California?
Yes, I do.
Isn't it correct that in that case you testified to the fact that if there is this cross-check on enough samples, that that is a significant method of validation?
Needs to be confronted with the specifics.
Same
Objection needs to be confronted with the
Sustained.
specifics.
form of the question.
Dr. Gerdes, with regard to this McIntosh case, didn't you testify in that case under a year ago?
Yes,
And isn't it in that case that you made that specific comment that I just read to you?
I may have.
Counsel, do you have volume, line, page?
Could we approach the bench?
You need to have that.
Can I proceed and return to that, Your Honor?
I'm going to move to strike unless he can show us a specific reference.
Proceed.
Thank you.
It will be subject to a motion to strike, though.
In your view, Dr. Gerdes, is a 5-probe RFLP match a significant match?
Yes,
What about a 6-probe match? Is that significant?
yes,
An 8-probe match?
yes,
Is a 14-probe match on a sample significant as far as RFLP typing?
yes.
Is a 14-probe match significant whether it's PCR or RFLP on a sample?
You know, it depends on the samples. We need to, again, you know, all of these are significant in terms of the number of matches, but you have to, of course, take into consideration the nature of the sample, whether there's a mixture or not. There are other things that complicate this issue. I can't just give you a blanket statement that that many probes is significant unless I know the nature of the samples and whether they're mixtures and those sorts of issues.
If you see a sample that's a 6-probe match that's showing either 1 or 2 bands that clearly match the 1 or 2 bands that an individual has, that's a significant match, isn't it?
Vague.
Yes,
And whether it's 8 or 14, if 6 is significant, anything higher is more significant, isn't that right?
that's true.
Now, as far as this case, did you examine the RFLP results obtained by the laboratories in this case?
I did.
And you are familiar with them?
Yes,
Isn't it correct, Dr. Gerdes, that as far as the RFLP and PCR results in this case, that the RFLP results confirm the PCR results in this case?
in certain items, yes.
It's true on a number of items, isn't it?
Yes,
And in fact, this case involves many RFLP matches, doesn't it?
yes.
Have you seen a case with more RFLP matches in your history of consulting with criminal defendants?
Sustained.
Your Honor, at this time I have a board that I would like to be marked as people's next in order.
570? 570.
570?
570.
Actually, would it? I think in the normal place, if that's acceptable.
May I step down?
Yes. Now, Dr. Gerdes, I'd like to show you what's been marked. People's Exhibit 570, I believe.
570.
This board is entitled at the top Results of RFLP DNA Analysis, is that right?
Yes.
And then there appear to be a number of different samples listed on the far left, is that right?
Yes.
And then across to the right are columns entitled basically which laboratory produced the result,
Yes.
followed by what the RFLP results were in terms of the number of probes.
Yes.
And then lastly, individuals who are not excluded from those particular samples as having been the donors of the DNA. Is that right?
That's right.
Now, turning your attention first, there appear to be 4 samples from LAPD item number 9, the glove. Is that correct?
Yes.
And on those, and let's start with the first sample, and can we use G1? Is that a way of telling the 4 samples apart?
Yes.
That sample revealed results from the Department of Justice after testing at 5 RFLP probes, correct?
Correct.
And those results excluded, that is, indicated a mixture of Nicole Brown and Ronald Goldman, correct?
Correct.
In your testimony, you have not criticized the accuracy of that result, correct?
That's correct.
And in fact, in your testimony, you have conceded that that result is accurate.
Yes.
Incidentally, when you use the term, what does a significant match mean? I'm not sure that question was clear. Let me rephrase it. As far as a 5-probe match or a 6-probe match and so on being a significant match, what does the term significant mean in that context to you?
As you know, there's a controversy as to how, what level of significance there is. But in my opinion, 5 probes would be certainly very significant in terms of putting some weight as to that match.
And in fact, in your opinion, that would be strong evidence that in fact a sample that matches at 5 probes came from a particular individual who matches that sample.
Again, it's controversial, and I'm not a population biologist. I'm not involved in that controversy, but it would be, in my opinion, significant.
When you perform a paternity analysis, how many probes do you routinely use in determining whether or not a father is the father of a child?
Paternity, you're comparing apples and oranges. It's a different statistics. It's done in an entirely different way, so it's really not a good comparison, but we do use 5 probes.
5 probes?
Yeah.
Would that be the same number as were used on at least item G1?
Yes.
All right. Turning to G2, those results reflected a 5-probe RFLP match to both Nicole Brown and Ronald Goldman, correct?
Correct.
And you have no scientific criticism of that result.
No.
Turning to G3, that result revealed an 8-probe match to Ronald Goldman, correct?
Yes.
And in your view, that result was appropriate, correct?
Yes.
And then lastly, on the gloved area G4, the results showed a 5-probe RFLP match to both Ronald Goldman and Nicole Brown, correct?
Correct.
No criticism of that result.
That's correct.
Turning to the Rockingham foyer, item number 12, Cellmark produced a 5-probe match to Mr. Simpson using RFLP, correct?
Correct.
You don't have any criticism of the accuracy of the results obtained by Cellmark, correct?
That's correct.
Turning to the sock, in fact, there were a total of, and let's start with the ankle area, both the Department of Justice and Cellmark tested the ankle area of the sock using RFLP, correct?
Correct.
That testing revealed at the Department of Justice an 11-probe match to Nicole Brown, correct?
Correct.
Cellmark also probed staining from that same sample at 5 probes, is that right?
Correct.
How many probes does that total?
16.
Is that then a 16-probe match with Nicole Brown?
It is.
If 2 of the probes used by Cellmark and DOJ were the same, would it then be a 14-probe match in reality?
Yes.
And that's in fact the case, isn't it, Dr.
Yes.
Gerdes?
Yes.
That 2 of the probes used by those laboratories are the same.
Yes.
You have no quarrel with the accuracy of the results on the sock, is that right?
That's correct.
Turning to the Bundy walkway, item number 52, Cellmark produced a 5-probe match with Mr. Simpson, correct?
Correct.
And in fact, that data correctly reveals a 5-probe match with Mr. Simpson, correct?
In this particular item, there's very little DNA, and in this particular item, I disagree with that.
Is it your opinion that Dr. Cotton was incorrect when she concluded that that match existed with regard to Mr. Simpson?
She's not incorrect in concluding the match, but the source of the DNA here is what the issue is. That's where the question is. There's very little DNA. It's down at the level of DNA where cross-contamination could be the explanation. And the circumstances under which that particular item was handled makes that a a distinct possibility.
Dr. Gerdes, is it your testimony that the RFLP results on item number 52 came from contamination?
Yes.
And in fact, is it your opinion to a reasonable scientific certainty that item 52 revealed DNA that was not from the donor of the blood stain, but in fact came from another source?
I think it's consistent with that.
You're not offering an opinion that it came, but you're raising the possibility. Is that correct?
That's correct.
Turning to item number 78, the Ronald Goldman boot drop, that revealed a 5-probe match to Nicole Brown and Ronald Goldman, correct?
Correct.
And then lastly on this board, referring to item number 117, the Bundy rear gate. First of all, how many probes? There doesn't appear to be anything written in under RFLP results, correct?
Correct.
Can you tell us how many probes that sample matched Mr. Simpson at?
I don't recall offhand, at least 5, but I'm not sure how many they did.
All right. Is that something that you can determine from your notes?
I did not bring the RFLP notes with me.
Are they available in the courtroom? As far as your notes?
My notes, no.
Yes. All right.
I can suggest
I'm sorry, Your Honor. Just object to counsel's comments. Thank you.
Proceed.
Dr. Gerdes, are you guessing that it was at 5 probes?
Unless I looked that up, I don't know exactly how many probes that there were on that particular item.
Your testimony has revealed you have no criticism of that match to Mr. Simpson. Is that correct?
That's correct.
All right. Thank you, Your Honor. Incidentally, Dr. Gerdes, you're not familiar with the fact that there were serology tests conducted on many of these evidence items, correct?
We've gone over this.
It's merely foundational to the next question.
All right, proceed.
I'm not familiar with I have not seen the reports. I'm familiar that they were done, but I'm not familiar with the specifics.
Isn't it true that if the serology results confirmed, well, let me rephrase that. Isn't it true that if the serology results were consistent with the PCR results, that serology would be another methodology that the accuracy of the PCR results can be cross-checked against?
objection as the issues beyond the scope.
Sustained. We've already asked that question.
Do you utilize serology to confirm the accuracy of any of the results in your own laboratory?
It's the other way around. We have serological tests where we may do PCR to confirm that
So you use PCR to confirm the accuracy of your serology results?
in certain circumstances.
Incidentally, serologic techniques aren't nearly as sensitive as PCR, correct?
That's correct.
It would be much harder to cross-contaminate a sample and obtain a serological result than it would a PCR result, correct?
In general, that's true, yes.
In other words, cross-contamination isn't the same concern with serologic techniques because they're not as sensitive as PCR is to detect small amounts.
It depends. You have to look at the specific tests and so forth, but in general, that's true.
As far as cross-checking by these different techniques, PCR and RFLP, isn't it true that additional markers beyond DQ alpha, such as polymarker, the 5 polymarkers, and D1S80, give the analyst an opportunity to cross-check the accuracy of results even more?
Again, you have to talk about the specifics. In the polymarker system, there's a 2-probe. In most cases, there are 2 allele systems. 2 of them are 3 allele, and the rest are 2 allele systems. And if you're dealing with mixtures such as a contaminant would introduce, it's frequently not informative because you have only 2. You have an A and a B, and if you have both, then it includes everybody. So it's not quite as informative as DQ alpha at being able to look at the possibility of additional human DNA being there.
In other words, as to the polymarkers, they don't have a lot of different variations, correct, individually?
Right. That's correct.
But they can present very informative results when you look at many of them, such as the 5.
It's possible, yes.
D1S80 is another marker, correct?
Yes.
And in fact, it has more variations or different possible types than the 5 poly markers.
Yes.
Nail clippings, and perhaps we can deal with them all at once. Do they produce the same results on each of the 3 separate items?
Yes.
How many different genetic markers produced results consistent with Nicole Brown on each of them?
7.
And lastly, turning to the rear gate, stains 115, 116, and 117. As to item number 117, does 8 probes sound correct?
Yes.
As to the RFLP match with Mr. Simpson?
Yes.
How many different PCR markers were also consistent with Mr. Simpson?
There's 2.
Referring to DQ alpha and D1S80?
Correct.
Dr. Gerdes, isn't it the case that with respect to the Bundy blood results, the RFLP results confirm the PCR markers, whether it's 1 marker or all 7 markers?
On that one item, which it does on the face of it, yes.
All right. Your Honor, at this time, I would like to use Exhibit 260, a similar results board.
All right.
Dr. Gerdes, referring you to what's People's Exhibit 260, have you again either seen this board or a board with similar results?
Yeah.
This board contains a number of results obtained using PCR, correct?
Yes.
And for the record, this is results of DNA analysis of the Bronco.
Thank you, Your Honor. Referring you to the first sample, item number 23 from the interior of the Bronco, did that produce a result consistent with Mr. Simpson at 1 genetic marker type following PCR?
Yes.
Does this board in fact show PCR results only from inside the Bronco?
Yes.
Referring you to the second item, number 24, how many genetic markers were typed that were consistent with Mr. Simpson?
1.
Referring to 25, how many genetic markers were typed consistent with Mr. Simpson?
2.
Turning to the steering wheel, item number 29. First of all, how many genetic markers were actually typed following PCR?
6.
And with regard to those samples, is it your opinion also that from a review of those results, that neither Mr. Simpson nor Nicole Brown can be excluded?
Yes.
Item number 30, how many PCR genetic markers were used?
There are 2.
And 31?
2.
From the sidewall, item number 34, how many?
1.
Incidentally, 30, I neglected to ask this, 30 produced a result from 2 markers consistent with Mr. Simpson.
Yes.
31 produced a result at 2 markers consistent with both Mr. Simpson and Ronald Goldman.
Again, this is the item where the weak 1.3 is in contention as far as I'm concerned. But that's what they say here, yes.
In other words, you have some criticism of the interpretation of that 1.3 allele, correct?
That's correct.
Turning to item number 34, that result at 1 marker was consistent with Mr. Simpson?
Yes.
What about item 293, the carpet on the driver's side? How many markers produced results that were consistent with Nicole Brown?
There are 2.
And then lastly, if we can deal with 303, 304, and 305 together, were there in fact two genetic markers that were typed following PCR with those evidence samples?
Yeah, these are the evidence items, this last bunch that were collected 1 month later.
Objection, move to strike, non-responsive.
Sustain, answer stricken, juries to disregard. Ask the question again.
Dr. Gerdes, items 303, 304, and 305 were typed at how many genetic markers following PCR?
2.
And did they in fact produce results not excluding either Mr. Simpson, Ronald Goldman, or Nicole Brown?
That's what's listed.
And then lastly, Your Honor, at this time I'd like to utilize Exhibit 262, a similar result board. Doctor, again, People's Exhibit 262, is that a board again similar to one that you have seen either in this form or a different form?
Yes.
And with regard to the results, starting with sock number 13, that is the particular item that produced what was a total of a 16 probe match, but was 14 different probes consistent with Nicole Brown, correct?
Correct.
You have conceded, or you have offered the opinion, that that 14 probe match is in fact a correct one, is that right?
Correct.
With regard to that, is that a significant match at 14 probes?
Yes.
And in fact, that's, in your opinion, would that be an extremely significant match?
Again, there's controversy as to how to weight these things. In my opinion, yes, it would be.
I'm sorry, yes, it would be? That sample was typed also at PCR-based markers, wasn't it?
Yes.
How many?
2. Well, sorry, 7.
So 7 different genetic markers typed following PCR achieved the same results as far as consistency with Nicole Brown as the 14 RFLP probe matches, correct?
Correct.
In your opinion, is that an example of an important cross-check between PCR and RFLP results?
It can be looked at as a cross-check. Yes.
It is a cross-check, isn't it?
Yes.
If one of those PCR results produced a result that wasn't consistent with Nicole Brown, wouldn't that potentially raise a question about the reliability of PCR typing in forensics?
Yes.
That didn't occur in this case, did it, on this sample?
Not on this one.
Turning to the remainder, and perhaps we can deal with the remaining samples, that is 5 more evidence items, correct?
Yes.
And they were typed at 2 different genetic markers following PCR?
Yes.
They all produced, at least with regard, we better break it down a little bit. 42A2 produced results consistent with Mr. Simpson at 2 markers, correct?
Correct.
42A3 was actually typed using both PCR and RFLP, correct?
Correct.
And in fact, the RFLP results revealed an 8-probe match to Mr. Simpson on 42A3.
Yes.
The PCR results were consistent with that RFLP result, weren't they?
Yes.
And in fact, the PCR results and the RFLP results were the same in being consistent with Mr. Simpson.
Yes.
Turning to 42A4, was that typed at 2 different PCR genetic markers?
Yes.
Did that in fact produce a result consistent with Mr. Simpson?
Yes.
And then lastly, turning to 42B1 and 42B2, how many genetic markers were typed with those 2 samples?
2.
Producing results consistent with Nicole Brown, correct?
With the exception of 42B2, where this trace 1.2 needs to be interpreted.
In your view, is that possible trace 1.2 the result of real DNA or not?
That's the issue here. When you have traces in this system, you can't tell.
Well, I'm asking you with regard to that sample, what's your opinion?
In that particular sample, I don't know.
All right, thank you, Your Honor.
Are we done with 262?
Yes. The court was going to take a break.
10:30.
Very well. One more board I would ask to be marked as equals 561.
571.
571. For the record, this board could be described as a board labeled concordance of cell mark results with DOJ results.
Yes.
Dr. Gerdes, with respect to, and let's start with the first item, 13A1, is it correct, and we've discussed this to some extent a few moments ago, that the RFLP results obtained by each laboratory were consistent with one another, correct?
Correct.
And that's with the fact that as to that sample, there were a number of RFLP probes that matched Nicole Brown, correct?
Correct.
Is that an example of, as you've used the term, significant match?
Yes.
There were also PCR results that you described a few moments ago that were also consistent with Nicole Brown from each laboratory, correct?
On that item, yes.
And in fact, cell marks DQ alpha and polymarker results were consistent with the Department of Justice's DQ alpha and D1S80 results, correct?
Correct.
Would this be an example where different laboratories achieved the same results from the same sample?
Yes.
Turning to the steering wheel, that particular item was typed by Cellmark at 6 genetic markers and by DOJ at one of the same markers, DQ alpha, correct?
Correct.
Those results were consistent with one another, weren't they?
Yes.
Turning to item 47 on the Bundy walkway, Cellmark's 6 genetic marker results were consistent with DOJ's 2 genetic marker results, one of which was typed by both laboratories. One marker.
Yes.
Turning to item number 48 from the Bundy walkway, is it correct that the 6 genetic markers typed by Cellmark were consistent with the 2 genetic markers typed by the Department of Justice, again, one of which was the same DQ alpha marker?
Yes.
In these instances, 47, 48, in fact, 2 laboratories tested material from the same sample using the same genetic marker, didn't they?
Yes.
Doesn't that constitute a cross-check of the accuracy of typing results by a laboratory?
Typing that item? Yes.
Turning to item 50, again, 6 genetic markers were typed at Cellmark and 2 genetic markers at DOJ, one of which was the same DQ alpha marker.
Yes.
And in this series, item 52 produced RFLP results obtained by Cellmark, correct?
Yes.
And 6 additional genetic markers following PCR at Cellmark.
Yes.
And then again, 2 PCR-based markers were typed at the Department of Justice, obtaining results the same as at Cellmark, correct?
For that DNA, yes.
And then lastly, turning to item number 84, and that was a series of 3 different samples from fingernail clippings and scrapings, correct?
Correct.
Actually had 3 different numbers because there were 3 different items. With regard to that sample, Cellmark typed them at 6 genetic markers,
Yes.
consistent with Nicole Simpson,
Yes.
Nicole Brown Simpson,
Yes.
and DOJ typed those samples at 1 genetic marker, correct?
Correct.
And as far as the results from those 2 different laboratories, they are in fact consistent with one another in terms of the fact that Nicole Brown could not be excluded as the donor of that DNA, correct?
That's correct.
Isn't this interlaboratory comparison In fact, when one looks at the number of samples, a cross-check of the accuracy of results.
It's a cross-check of the items that were extracted by those labs. Yes.
All right, Your Honor, I was going to change into another area that was going to actually be my final area, but it will take longer than 5 minutes.
Well, let's use the 5 minutes we have.
Very well. Dr. Gerdes, this case doesn't involve testing of 1 or 2 evidence items, such as 1 or 2 bloodstains on a sidewalk, does it?
That's true.
In fact, in this case, there are more than 40 different evidence samples that produced DNA typing results. Isn't that correct?
That sounds about right.
Isn't it correct that with respect to the negative controls in this case, unstained substrate controls, that's one negative control, correct?
Correct.
A reagent blank, is that another negative control for PCR typing?
Correct.
There's also a negative amplification control, as we discussed last Friday or Thursday.
Correct.
Isn't it correct that all of those controls, the substrate controls, the reagent blanks, the negative amplification controls in this case show no evidence of contamination?
There's one item from Cellmark that's a reagent blank that shows some evidence of contamination. With that one exception, all of the rest appear clean.
How many different runs do these approximately 40 or more than 40 evidence items include in this case? I'm referring to PCR runs.
No, I haven't counted them.
Well, would
But,
samples be
I
run
would-
more than once?
Yes.
How many
Some
times?
samples, other samples not.
So some samples would be run one time?
Yes.
What's the most another sample? I'm referring to evidence materials. What's the most times another sample would be run?
Vague and repetitive.
Sustained. It's vague.
In terms of the use of the term run,
All right, let the record reflect that we've been rejoined by all the members of our jury panel. Dr. John Gerdes is on the witness stand undergoing cross-examination by Mr. Clarke. And Mr. Clarke, you may conclude. Thank you, Your Honor. You're welcome.
I have a moment with counsel.
What is this?
Transcripts.
All right, with the court reporter, please. Proceed.
Thank you, Your Honor. Dr. Gerdes, with regard to the LAPD's DNA testing in this case, you have described previously that Mr. Yamauchi conducted PCR typing in this case on June 14 and June 15, correct?
Correct.
And in that testing, he used the controls that you previously described as a result of my asking questions about reagent blanks and so forth, correct?
Correct.
Now, Your Honor, I have another document, one more document I'd ask to be marked as People's, I believe, 572, which I've previously shown to counsel, and with the court's permission, I will display it on the Elmo.
Proceed.
Dr. Gerdes, can you see that?
I'd like to step
That's
down
fine.
if I can.
First of all, this particular document or slide, as is now on the screen, have you had a chance to see that or take a look at it last week?
I saw it briefly, yes.
And did you have an opportunity to calculate the total number of evidence samples, known standards, and controls that Mr. Yamauchi used in his testing in this case?
Yes.
Now, with regard to, and there were two different dates for this testing, is that right?
That's correct.
And on both June 14th and June 15th, Mr. Yamauchi typed evidence samples.
Yes.
He also typed known standards from the three people in this case.
Yes.
And he also utilized a series of controls, is that right?
Yes.
As far as the known standards, do you call those a control or not?
They are in the sense that they are defined as coming from a single individual, and if you can find evidence of human DNA, additional human DNA, that's evidence of contamination.
So, in a sense, the known standards can act as a control, correct?
Correct.
So that if a person was a, let's say, a DQ alpha 1.1, 1.2, and you saw a 3 and a 4 showing up in addition to the 1.1 and 1.2, that's again another opportunity for contamination to signal itself, at least in that sample.
That's correct.
Now, as far as the total number of samples typed by Mr. Yamauchi, is it correct that including both June 14th and June 15th, he typed a total of 42 different samples?
That's correct.
That consisted of 18 evidence samples, whether it's a stain from the sidewalk at Bundy or a sample from the Bronco, correct?
Correct.
Or other samples that he typed as well.
Correct.
He also typed the three known standards from the three individuals in this case, Mr. Simpson, Ms. Brown, and Mr. Goldman.
That's correct.
The total number of evidence and known standards was 21, is that right?
Yes.
And is it also correct that the total number of controls used in this case by Mr. Yamauchi on June 14 and 15 was 21?
Yes.
Is it then correct that of the 42 samples typed by Mr. Yamauchi in this case on June 14th and June 15th, half of them, that is 50%, were controls?
On this specific case, yes.
In your view, is that an adequate number of controls for typing?
It should be.
And in fact it is, isn't it?
Yes.
All right, thank you. Now, Dr. Gerdes, you have last Wednesday and Thursday repeatedly used terms like my interpretation, possibility, and risk. Do you recall using those words?
Yes.
And that was in reference to your testimony about the dangers of contamination in this case, correct?
Yes.
You can't quantify that risk, can you? That is, put a number on the risk.
Well, if there were adequate blind proficiency studies, at least you could have some idea about error rate, which would give you some idea of risk. And the other thing that you can do is, as I've done here, you can look at all of the testing around the time frame of the testing done in an instant case and see how many times errors were made and how many times there was evidence of contamination. So they are, those are objective ways of measuring the amount of risk, but as to coming up with a number that's a specific number that's going to say 80% of the time you'll make a mistake or something like that, no, you can't quantify it.
And in fact, you testified about what you believe to be errors in the laboratory, and we went through each of the 5, correct?
Yes, we did.
Now, as far as your laboratory's work in diagnosis of diseases, you produce results that ultimately go to a doctor, correct?
Correct.
And a doctor is required to notify that patient of risks no matter how unlikely they are to occur, correct?
Yes.
Are you aware of the non-blood stain evidence in this case?
You mean fibers, hair, etc.?
All the other evidence in this case?
Peripherally.
Outside the scope or relevant?
Overruled.
When you say peripherally, doctor, what do you mean?
Well, I certainly did not review specific documents as to those things outside of my field, but I'm aware of them because of media coverage, and just like anybody else would be.
So watching TV, that would be one source?
Yes,
Reading the newspaper?
yes,
Reading magazines, if you do?
yes.
You have also testified that it's ultimately for the jury to decide the reliability of the scientific evidence in this case. Do you recall saying that?
Yes,
Is it also correct that it is ultimately for the jury to decide whether in fact any contamination occurred in this case?
that's up to their discretion, yes.
All you have told this jury is that there might be contamination in this case, correct?
I believe I've documented as precisely as I can the level of contamination that exists, and from that point on, I've suggested how that may have, or tried to explain how that would have an impact on the case. From that point on, it's up to the jury to deal with that piece of evidence and in the context of the whole case.
You have talked about, Dr. Gerdes, possibilities, not what actually happened, correct?
Calls for conclusions.
Sustained. It's argumentative.
You have spoken, you have described what you'd believe to be possibilities in this case. Is that right?
I have, as objectively as possible, evaluated the level of contamination at LAPD, the errors that I felt were a result of that, the evidence of cross-contamination in the reference samples, and the implications of that in terms of the evidence in this case. That's what I've attempted to explain.
You've spoken about what could happen, not what did happen, correct?
I don't have 100% assurance that that did happen. I have no scientific confidence that it couldn't have happened.
Dr. Gerdes, the results in this case from 3 different laboratories are consistent with the defendant's blood being left at the crime scene, aren't they?
The results from the 3 labs, as far as reported results, yes.
They are consistent with mixtures of DNA from the defendant, Ronald Goldman, and Nicole Brown being found in the Ford Bronco. Isn't that correct?
The results are consistent with that as they're detected.
Incidentally, you haven't suggested to this jury that the defendant's reference sample cross-contaminated the evidence taken from the Bronco, have you?
The fact that I have some indications of cross-contamination in those reference samples obviously increases, again, the risk that it could cross-contaminate something else.
Dr. Gerdes, what I'm asking you is you haven't suggested to this jury that the defendant's reference sample cross-contaminated any evidence in the Bronco, have you?
His particular sample?
Correct.
It's hard to tell. I mean, I have no evidence, specific evidence, hard evidence of that.
You don't have any evidence of it whatsoever, do you?
I have some evidence that the reference samples themselves may have cross-contaminated. At that point, everything becomes suspicious.
Dr. Gerdes, what I'm asking you is, you don't have any evidence whatsoever that the defendant's reference sample cross-contaminated any of the stains from the Bronco.
I don't have any direct evidence of that, no.
Where in the history of these samples did the defendant's reference sample come into even potential contact with the Bronco evidence samples?
There are other items that were collected at that residence who arguably may have come from the defendant. And it may not have been the reference sample, but it may have been some of those items.
Dr. Gerdes, what I'm asking you is, with regard to the defendant's reference sample, when did it come into any potential contact with the Bronco evidence stains?
It didn't.
The results in this case, Dr. Gerdes, are consistent with the defendant's blood leading up to and inside his home on Rockingham. Isn't that correct?
The typing results appear that way, yes.
Those results are consistent with Nicole Brown and Ronald Goldman's blood being found on the glove at Rockingham, correct?
Again, there are multiple explanations. That's one explanation.
Dr. Gerdes, didn't you concede last week that the RFLP matches to the two victims on the glove were correct?
Yes.
Dr. Gerdes, isn't it true that the DNA typing results from the laboratories in this case are consistent with Nicole Brown's and Mr. Simpson's blood being on the sock found at the residence?
Yes, that's true.
And in fact, you've conceded that much during your testimony, correct?
I have.
Now, 5 probes as a match is significant, correct?
We have gone through this part.
When you conduct your paternity testing, you look at individual probes, correct?
Correct.
You look at more than one probe because a father might be excluded as being the father of a particular child, correct?
Yes.
And in fact, you look at routinely 5 different genetic markers, is that right?
That's correct. We're doing DNA only.
Just counting DNA, right?
Yes.
And you're looking at each of those markers, is this potential father or this person who might be the father excluded as the father of that child, correct?
Correct.
Once you look at those probes, you then estimate how rare is that match at one probe.
Sustained. So we've gone through this already.
Dr. Gerdes, one of the concerns that you have expressed in forensics is the fact that a sample may be small and you may not be able to retest it, correct?
Correct.
Now, as far as errors, and you described how in medical diagnostics, if a patient dies because of a misdiagnosis, you know you've made a mistake. Is that right?
That's a pretty drastic example, but yes.
And you described the fact last week that in your view there is no independent way of assessing whether or not mistakes are made in the forensic setting. Do you recall that?
I believe that's true.
Are you aware of remaining evidence in this case that can be retested?
I'm not aware of any evidence that hasn't been handled by the LAPD that can be retested.
Objection, move to strike, non-responsive. Dr. Gerdes, are you aware of remaining evidence in this case that can be retested?
There are items that can be retested.
There are a number of evidence items, aren't there?
Yes.
And in fact, there are remaining swatches from many of the very items that we've described, that you've described during your testimony in this case.
There are.
Whether it's the Bundy blood drops,
Correct.
whether it's DNA removed from the Bronco,
Correct.
whether it's DNA from the defendant's home,
Correct.
whether it's DNA on the glove,
Correct.
whether it's DNA on the socks.
Correct.
Have you tested any of that?
We don't do this type of testing.
Well, as far as the difference between the testing you do in your laboratory and forensic labs do, you've testified the only difference is the nature of the specimen, a blood stain versus a blood vial, correct?
No, I believe I testified that it's comparing apples and oranges, that there's a completely different setup and statistics involved in paternity from forensics. They really are not the same, other than the fact that the methodology itself, as far as how you run the gels, is the same.
Dr. Gerdes, if you exclude somebody, statistics don't mean anything, do they?
That's true.
In other words, if you test a sample and at a genetic marker someone's excluded as having left a sample at a crime scene, let's say, numbers don't mean a thing.
That's right.
As far as in your laboratory, you have tested the DQ alpha marker before, correct?
Not in a forensic sense.
Have you tested the DQ alpha marker before, doctor?
Yes.
And in that testing, did you feel competent to perform that testing of the DQ alpha marker?
Yes.
As far as removing DNA from a blood stain, do you feel that you could do that?
Yes, I could do that, but the difficulty is, as we've discussed over and over, whether that's you need to have confidence. The difference in the way I do things and the way forensics do that is I have confidence that a specimen I'm working with came from a single individual. And the complications in terms of statistics, interpretation, potential error that's introduced by the fact that these are mixtures or potentially mixtures, that's the issue.
Dr. Gerdes, if one of those samples from the bloody blood drop trail, 47 through 52, if one of those was typed and it revealed a genetic marker, and I'm referring to the remaining evidence, that excluded Mr. Simpson, wouldn't that be important?
Yes,
That would be extremely important, wouldn't it?
yes.
Have you suggested to the defense in this case that retesting should be done?
Sustained.
Objection, move to strike and ask for an instruction
Forward.
on burdens of proof.
Wouldn't reanalysis of these samples support, if they produced exclusionary results, support your opinions in this case?
Objection.
Overruled.
Not at this point.
Is it your view then that if further testing in this case revealed Mr. Simpson was excluded from item 52, that wouldn't support any of the opinions you've offered in this case about forensic DNA typing?
In my opinion, with the risk of contamination, there would be no possible PCR interpretation possible at this point because the samples have been handled in the way they have been.
Are you aware of other laboratories?
Keep going.
Are you aware of other laboratories, doctor, that perform forensic retesting?
Yes,
Does Dr. Blake, is he able to perform DQ alpha typing on forensic specimens?
yes,
Is Mr. Taylor able to perform retesting on forensic specimens?
yes,
Is Dr. Lee able to perform forensic testing on specimens using DNA typing?
yes.
Nothing further, Your Honor.
We have,
All right, ladies and gentlemen, there's a couple of things I need to take up out of your presence, so I'm going to ask you to step back into the jury room. We'll call you out in probably 10 or 15 minutes. All right, Dr. Gerdes, you can step down. All right, the record should reflect all the jurors that withdrawn from the courtroom. Mr. Scheck.
first, Mr. Cochran has an application.
As to this issue, I'd like to just address the court, Your Honor, as to one issue. Your Honor, repeatedly we've seen questioning by the prosecutors with regard to the defense could do this, the defense could do that. And I think that's grossly unfair to Mr. Simpson, because the court is aware the defendant doesn't have to prove anything. You just hark back to the voir dire. You've told this jury Mr. Simpson could go to sleep if he wanted to. Now, obviously, he hasn't done that in this case. But I think it's terribly unfair under the provisions of the state constitution, the U.S. Constitution, to try to shift the burden to Mr. Simpson. He does not have to prove anything. And I think that whole line of questioning is unfair. I'm making this objection primarily because I think it applies not only to this witness, but to others. And what I'm asking the court to do is to prohibit the prosecution from doing this, and also at the appropriate time you will be instructing this jury, but to instruct them, the defense does not have to do any kind of testing in this particular case. And I think it's unfair. It's unfair inference. You've mentioned Mr. Blake 100 times, and now we hear Blake and Taylor and what Gerdes could have done, and that's really unfair, Your Honor. And I wanted to at least address the court on this and ask you to give a curative instruction in that regard.
All right, that will be given and has been given as the court's normal instructions, that the burden is on the prosecution. However, there's also a long line of cases that during the course of argument, the prosecution can argue the failure to call logical witnesses.
But doesn't it fly in the face, my point is, just briefly, Your Honor, not to belabor it, doesn't it fly in the face of where you start off instructing the jury, we don't have to prove anything. Then they come along and they do exactly that, and then you instruct them that we don't have to prove anything. So I
have
think
instructed them in the most graphic and simple way as I can, that Mr. Simpson can sit here and sleep through the whole trial if he cares to.
you did that. And so what I'm
And
saying
that's
is,
something that even you remember, Mr. Cochran.
I remember that, and
correct?
I remember that, Your Honor, and I just reminded you
I'm
of that.
sure
Right.
the jury
Right.
remembers that one too.
Right.
That's why I use it.
Right, but, and I appreciate that, Your Honor. But in addition to that, then it seems to me to be an incongruity for them to continue to throw up this thing as though we have to prove something or we have to do something, because we don't have to. And I think that's grossly unfair, and that's the point.
Well, I will instruct the jury at the appropriate time, that the burden is completely and 100% on the prosecution. Rest assured of that. All right, Mr. Scheck.
Your Honor, we have some slides that I'll hand up to the court. I have give to the prosecution. Should I, maybe, what's the best way you want to do? You want to just take a look at them or put them up?
Just hand them to me.
Maybe, Howard, could we just go through them?
Do you have any extra copies? So we
Yes, I have these right here. Perhaps if I just go through them.
I haven't seen them, Your Honor.
Yeah. These slides would be used in conjunction with, they address the 4 different examples of errors at LAPD. And if we could turn to,
All right, these are the same 4, or depending on how you call it, 5 mistakes that Mr. Clarke went through, correct?
right,
And this is an illustration of the different calls, correct?
yes, this would be a breakout of the genotypes listed on prosecution's exhibit number 561, which are the strips. And what it indicates here is the correct type in the proficiency testing sample being 1.2, 1.3 for the sperm fraction, and it's labeled with the sign for males. And the LAPD type is recorded, which was a 1.24, and it indicates the female fraction, and indicates that this was, as the testimony indicates, done first by Colin Yamauchi on 9/9/93, and then again, Aaron Riley did the same sample, got the same result on 9/21/93. Next slide, please. This indicates,
All right, counsel, I have all of these in front of me.
yes. The next thing is indicates that,
All right, well, rather than sit here and tell me what they are, what are your objections, Mr. Clarke?
I think this, at least this slide is argumentative and misleading. As far as this witness's own testimony about, and the witness conceded that yes, these people cannot be excluded, even persons with a different type, because of the potential for this spillover of female DNA into male DNA. So just judging by, in particular, the portion of the slide that's in black on the right, this witness has conceded that no, you wouldn't wrongfully include anyone, you wouldn't wrongfully exclude anyone, because the analyst, a trained analyst, must necessarily consider that may be the victim's DNA that's coming out in the sperm fraction. If
All
the
right.
witness hadn't conceded that, I think we'd be in a different situation.
that's not his testimony.
Wait,
and-
wait, wait, wait. Mr. Scheck, A1, B2, and C3, these are all casework examples, correct?
B-
Are these casework or validation studies?
what these slides refer to,
I know, the 4 or 5 mistakes. I know what we're
Right, that's
talking
right.
about here.
this one is a mock validation study.
Okay.
And the point that Dr. Gerdes made on direct, and we feel has to be cleared up, because it's very hard when you deal with these sheets. You have to break out the types and show exactly what the points are, that the typing result of LAPD of a 1.24 could be, if that, given the fact that the female fraction is a 1.24, the number of different possible suspects in terms of genotypes that could be included by that result in a casework call would have been a 4.4, a 1.24, and a 1.2, 1.2. And that's why he considers this a mistake, and a serious mistake, and the kind of thing that he's seen in other forensic laboratories, and that's
All
our
right.
point.
Mr. Clarke, any other comment on all of these matters?
Referring to this first slide?
No, any of them.
Oh, actually, I haven't had a chance to look at the others. We've been dealing with this one.
Do you have them all printed in front of you?
Yes.
Because they're all similar. They're two different batches here.
If I could look at them.
All right, Mr. Scheck, my one concern is that A1, B2, and C3 are not self-labeled as being mock validation studies.
Well, what I would do is, when we put this up, I'll label
Whereas the
them.
others do clearly say this is proficiency testing.
I see. So, we'll. Howard, do you want capability? We'll have Mr. Harris put it on the slide. I'll also refer to the exhibits when I show the slide, so it's clear what we're referring to.
I also think as to the wrong suspects included, that's very argumentative and misleading in view of what
It's inaccurate in terms of a mock.
Well, we put down mock. It's not a real case. It didn't really happen. The point is, it could happen if there were a real case, and that's his testimony.
even in a mock case, it's extremely misleading. That's
All
the
right,
difficulty.
but here's the problem, is we all agree that we've gone through all 4 or 5 of these on both sides. This is a graphic breakout of what's there. I think it's easier to understand in this form as long as it's correctly labeled what it is. That's my only problem with it.
So we should put down, we'll put down mock validation study underneath the 993 rerun 921.
Right, as to A1, B2, and C3.
Yes.
All right, anything else?